Welcome to the Iowa Court of Appeals for this 2:30 afternoon session. We have 3 cases to hear. The first of those is Ryan Mosley versus the Quad City Hockey Association et al. It's number 250053. We have the attorney for the Appellant-Nicholas Huffmon and attorney for the Appellees, Richard Davison. Okay, we have Megan Gorham and Mr. Okay, Matt, thank you. Okay, thank you. Whenever you're ready, Counsel.
Thank you, Your Honor. May it please the court. Opposing counsel. I'm Nicholas Huffmon on behalf of plaintiff appellant Ryan Mosley. It is well established in the state of Iowa and elsewhere that a party cannot be compelled to arbitrate a dispute that they did not contractually agree to arbitrate. I believe that principle is central to the case in front of you. Here, Mr. Mosley is exclusively asserting civil claims against the defendants for monetary damages. Generally stated, those claims are for breach of fiduciary duty, breach of contract, and conspiracy. Now, the defendants claim that all of these claims are subject to ADR because Mosley supposedly agreed to a registration waiver containing an ADR provision.
Look at that waiver, the opening paragraph, the all capitalized waiver. It talks about the purpose of the agreement. Is that also sort of the substantive content of the agreement too, or is that reference to purpose kind of set it aside?
Well, I believe that is a general statement of purpose that is included in there to sort of explain the rest of the document and should be used for kind of interpretive purposes, because it does say that the purpose is to waive personal injury claims, property damage claims, wrongful death claims. So I read the registration waiver as very specifically focused on only waiving those kinds of claims, and that's what a reasonable person would understand that document to mean, and that's, if someone were to agree to that, they would only be understanding that they are agreeing to waive those kinds of personal injury, property damage, tort claims. Now, as an initial matter, the defendants, who of course bear the burden on their motion for summary judgment, have failed to produce any evidence of what a user would actually see in the year in question. Now, it appears that Mr. Mosley's last year with the Quad City Hockey Association was in 2019 or 2020. But if you look at their Exhibit B, which is the primary affidavit that they rely on from a director at USA Hockey, it very significantly and repeatedly relies on screenshots from the 2023 registration portal. It's the 2022-2023 registration portal. I don't believe there's anywhere in the record where it says what a user in 2019 would have actually seen and what they would have been agreeing to. Now, we only have receipts from after the fact for the 2019 year. That's at the end of that same exhibit. And of course, that exact same affidavit in paragraph 42 says that some of the language in the waiver of liability has been updated in subsequent years after they started using it. And also I find it very significant, and this is not in the briefing because I discovered it after the briefing was submitted, but the bylaws that are on the docket are for the years 2021 and 2022. That obviously cannot apply to the 2019 or 2020 years. So I don't believe that the actual relevant language of the arbitration clause is even in the summary judgment record before this court. But in any event, even assuming that the documents that we have are, as presented by the defendants, are valid, I think their argument still fails because the claims in this case are clearly outside of those documents. Now, ADR provisions are treated sort of equally with other contractual provisions, and what we have here is that this document should be construed against the defendants for really two separate reasons. The first is that they drafted this document, either they did or their parent organization, USA Hockey, and this document should be construed against the draftsman. And also that this document was presented on a take-it-or-leave-it basis to Mr. Mosley, so it's obviously a contract of adhesion.
Talk a little bit about the overlap or the relationship between that waiver provision in the registration and the bylaws, I think specifically bylaw 10.
That's correct, Your Honor. So obviously my client did not sign the bylaws or anything like that. The relationship is that according to the defendants, he supposedly agreed to the registration waiver, and about midway through the registration waiver, it says that the participant agrees to be bound by the bylaws, which would have to be, I guess, accessed separately, or perhaps there was a link. I don't recall off the top of my head, but yeah. But that was the defendant's only basis for saying that my client is bound by the bylaws, is that they were referenced in the registration waiver.
Counsel, doesn't bylaw 10, I believe it's point G sub 3 sub G, state explicitly that arbitration procedures, and I quote, do not apply to monetary claims or disputes between the parties, unquote. Is your claim one for monetary damages?
All of our claims are for monetary damages. You'll not find any kind of specific performance or anything of that nature.
So why are we even talking about the bylaws?
Well, I can only say that the defendants have obviously raised them. So I've of course raised the language that you are referencing. I've also raised a different exclusion. I don't have the exact number in front of me, but it is under the unified procedure, which is also in bylaw 10, where it says that torts or other civil claims are not subject to the unified procedure. I believe that also knocks out that option. So, but since we're on the topic of bylaw 10, I want to note that there are only 4 different procedures for ADR provisions in bylaw 10. There's the unified procedure, appeals, national suspensions, and arbitration. Of those, I think only the first one, unified procedure, and the last one for arbitration are even worth discussing. And as we've sort of gone over, there are exclusions for civil and monetary claims in both the unified procedure and arbitration. So neither of those can apply here. So that means that there simply is no procedure that we could even go to, I think, in this case.
Counsel, you made some mention in your brief about some discovery issues and the district court's denial of your request for discovery. Are you raising that as a separate issue on appeal?
Well, yes, I am. I think those are obviously sort of connected because we've filed a sub 6 part of our briefing asking for additional discovery. But I do believe that those were in the same motion, and that if this court can't rule in my client's favor just on the record in front of it, that it would have been appropriate for the district court to allow that discovery. I think it was an abuse of discretion not to allow that kind of discovery, because what you have here is that the defendants were allowed to raise these ADR issues, but my client was not allowed to conduct the discovery in order to rebut those issues. And I believe that the discovery that we sent out and the numerous objections that were raised to it are on the docket in front of this court. So you can obviously see what we were attempting to obtain. And I think even in the motion for protective order, in our resistance to it, we identified these specific legal theories that we were attempting to pursue, such as waiver, estoppel, things of that nature. And I believe there were citations to the specific elements that we were trying to pursue, but the district court refused to allow that discovery. And lastly, I just want to note the line of cases that I don't believe the defendants have even attempted to address, starting with the Steinkamp case and continuing with Jiffy Lube, Wexler, and Rivich, which are all cited quite thoroughly. and discussed in my briefing. Obviously, Steinkamp is the notable Judge Posner decision, which talks about sort of the absurdity of an ADR provision that purports to cover all disputes or any and all disputes, and it questions, what would happen if sort of the company murdered someone, robbed them? Would those be covered by an ADR provision that covers any and all disputes? Presumably, the answer to that would have to be yes, and that's a decision that was agreed by the subsequent cases and found to be an absurd and unenforceable. And my time will expire, so unless there are further questions. Thank you.
Time on rebuttal.
May it please the court. Counsel. My name's Matt Jacobson. I'm here on behalf of the defendant Appellee Quad City Hockey Association. I am also here arguing on behalf of what I will just refer to as the individual defendants. Those defendants have played various roles as members of the Quad City Hockey Association, ranging from board members to directors to officers. The Quad City Hockey Association is a nonprofit private organization run by volunteers. They're responsible for hockey games, scheduling, clinics for approximately 400 youths and adults in the Quad Cities areas. As can be found on the tax returns, which are public record and posted on their website, none of the people who work for or advance the cause of the Quad City Hockey Association are paid. They are all volunteers. On April 3rd of 2019, Ryan Mosley, the plaintiff appellant in this case, just as he had for the 3 previous years, registered to be a member of the Quad City Hockey Association through the USA Hockey website. He went through the process that was detailed in affidavit by Kim Folsom from USA Hockey and paid a $56 registration fee to become a member. Part and parcel of that registration process, there is involved an agreement by which Mr. Mosley agrees to be bound by USA Hockey's bylaws.
I think as part of that registration too, there's the waiver provision, right, that appears at the top of the receipt from the registration?
What the receipt does is it replicates and reproduces the agreement by which Mr. Mosley or anybody registering with USA Hockey initialed as part of the registration process and agreed to.
Some of the language of that waiver provision, it limits its application to any negligent act or omission. What are we to make of that limitation?
If you could point me to the specific provision, are you looking at?
Purpose paragraph, I think, in the all capitalized paragraph.
Is that in the bylaws or is that in the?
The waiver of liability release.
In the waiver of liability, it reads, as a condition of registration and membership in USA Hockey, in member teams, participant agrees to abide by and be bound by the playing rules.
Before that, so if you look at Exhibit 2, waiver of liability, release, assumption of risk, and indemnity agreement, the very first paragraph after that heading, in all caps.
Sorry, it is the purpose of this agreement for the participant and participants' parents and guardians, if applicable, to exempt, waive, and relieve releasees from liability for personal injury, property damage, and wrongful death, including, if caused by negligence, including the negligence, if any, of all releasees. That is one of 11 paragraphs in what Mr. Mosley agreed to.
So how do Mr. Mosley's claim for breach of fiduciary duty, how would they fit into that restrictive language?
If you're focusing on only one of the 11 paragraphs, and you're going to ignore the paragraph number 6, which makes reference to his agreement to be bound by the bylaws of USA Hockey, if you want to read out all of that other provision, I suppose you can make an argument that it doesn't apply. But if you read the document as a whole, and everything to which it refers, then it is clear on its face that Mr. Mosley is agreeing to abide by the rules, including the bylaws of USA Hockey.
So would you agree then that but for the bylaws, the waiver is not applicable to fiduciary duty claims?
I don't know if I would concede that. I think that if,
And within that waiver would address specifically non-negligent conduct?
what you would have to look at is you would have to look at the agreement by which he is joining an organization that is a voluntary nonprofit. So what you would have to look at is the case law of whether or not Iowa courts want to intervene in how voluntary nonprofit associations go about their business. I believe Iowa, like any other state, is incredibly hesitant to allow that to happen because they prefer for those types of organizations to run themselves and to make decisions, to make rulings, to set their own rules. And instead of racing to a district court anytime that a member somehow feels aggrieved by a decision of that voluntary organization. Take it out of the context of this particular case. You go anywhere on a Saturday in the state of Iowa in the summer and you see kids playing baseball all over the place. Most of those baseball leagues are run by voluntary nonprofits now. I don't necessarily like that as an aside. I didn't grow up in that in Cascade, but it is what it is now. If somebody says, my child is not getting coached the way that I want my child to be coached, I'm going to file a lawsuit against the board of directors because I think they're breaching their fiduciary duty. I don't think they're giving me the value of that counselor.
And that, counsel, but the waiver could have been drafted in such a way, could it not have, to include that or specifically breach of fiduciary duties or in the alternative, any and all claims?
Well, I think if you look at the bylaws which are specifically incorporated in this provision, this overall provision.
Back though, counsel, and that's where I'm circling back to. So again, paragraph 6 relative to the bylaws, is that outside of that, if you were to take that paragraph out, would you agree that otherwise there's no exclusion to non-negligent conduct within the waiver?
The waiver, yes, but I think there's a bigger picture that also needs to be addressed as to whether or not somebody can file a $56 registration fee and then be open to the courts, the district courts and the juries of this state to regulate how private nonprofits are organized.
Governed by what the agreement says, though.
Yes, and the agreement says that the bylaws shall be adhered to.
The bylaws, then. Which provision of the bylaws, the 4 different types of alternative dispute resolution procedures, which one of those applies here?
Procedure.
How do his claims fit within that arbitration procedure? What provision? Because I didn't see you address that question in your briefing.
So if you look at bylaw 10, which is the dispute resolution, discipline, and arbitration agreement, that's at issue here. Very first paragraph. All claims, demands, discipline, or disputes arising by or between parties shall be subject to the provision of this bylaw 10, and this bylaw shall constitute the sole and exclusive remedy for dispute resolution. You go to the second, which identifies the purpose. It is the purpose to provide a uniform method of resolving disputes that is a full and complete substitute for any court proceedings and that utilizes the special skills, expertise, and background of individuals experienced in the sport of hockey and sports administration. Look at the 343 paragraphs spanning 50 pages of the plaintiff's petition. Each and every one of the complaints that he identifies over that amount of time all relate to how this organization is run by the various volunteers. It is specifically within their area of expertise to determine whether or not Mr. Mosley's claims that they are not following the rules, they are not following the regulations, they're violating codes of conduct, they are specifically set up for that. And if he doesn't want to raise his complaint with Quad City Hockey Association because that's too close, he goes to the Midwest Amateur Hockey Association. And if he doesn't like the result at the Midwest Amateur Hockey Association, there's an appeal process by which he goes to USA Hockey.
How are we to interpret bylaw 10.G sub 3 sub G?
For appeals, that's not part of the unified procedure.
Just explain that to me.
The appeals process comes at the end of various disciplinary actions that can be taken earlier in what's described as the unified procedure, and then there are exclusions from the unified procedure, and it identifies various actions that can be taken against individuals who have not complied, whether it's violations of codes of conduct, violations of bylaws. Then you have a separate procedure by which there can be summary suspensions that are issued. But the appeals portion is laid out in subsection E, and subsection G, to which you were previously referring, which starts on, I meant to flag it and I apologize that's the arbitration procedure. Certain actions can lead directly to arbitration after they have gone through the appeal procedures. And if it fits within that category, you go to arbitration. But as you note in section section G of that section, monetary claims or disputes are not subject to arbitration. So if, as the district court properly noted, Mr. Mosley goes through ADR, depending upon how that plays out, he would not have to go to arbitration. He could pursue his actions in district court and try to seek recourse at that particular time.
Sandy, did that answer your question? Or? Thank you. I see your time's expired.
Long.
Rebuttal. The point, a line that kind of jumped out for me from the district court decision, and I think this is kind of what Mr. Jacobson was getting at. The district court wrote that the core competencies of the court, whatever else they might be, do not include an intimate grasp of the administration of a hockey organization. Doesn't that sort of support the summary judgment ruling in this case?
Where did that quote come from? The ruling? The district court ruling? Well, we obviously disagree with the district court's ruling. I don't see any reason why a hockey association would be essentially outside the rule of law and above these kinds of claims that we're asserting. The breach of fiduciary duty, breach of contract, conspiracy. These are obviously very well-recognized legal theories. I'm not aware of any reason why they would not apply to a voluntary association or a hockey association or anything that would be relevant here. I also don't believe that's the issue before this court. That what we have legally before this court is whether these particular documents, the ADR provisions that the defendants raise, are enforceable. So I think that that particular quote would speak to the substance of these issues, which is not the basis for the ruling on summary judgment.
Do you agree with your colleague on the other side that your claims fall within the unified procedure process that's laid out in the bylaws?
I do not agree that this is covered by the unified procedure. This is the first I'm hearing that that's the defendant's position. But there's, I think, two separate issues why this cannot apply or fall within the unified procedure. The first is that the plain text of the bylaws for the unified procedure says that it only applies to discipline, which is a defined term. Essentially, it means suspension, probation, other kinds of discipline. And that's not what our case is about, that If you read the petition, you'll have all the allegations in front of you that we do make sort of a lengthy narrative, but it includes things like bullying, retaliation, misconduct in internal elections, allowing unqualified or non-credentialed persons to have jobs that they are not allowed to have. So this is not a discipline case. I know the defendants have cited discipline action taken against Mosley in their claims, but that's simply, I don't think that's really part of our petition. I think there might be short references in our petition to discipline just for narrative purposes, but this is fundamentally not any sort of challenge to a discipline. We're not asking for any sort of suspension to be revoked or anything of that nature.
Under the paragraph 6, I call it the bylaw paragraph, but that's inartful probably. The bylaw paragraph, about midway down, it states, any dispute, claim, or cause of action regarding, and here's the important part I want to emphasize, the terms of this agreement shall be brought, and then it goes on. So I want to talk about the definition of the terms of this agreement. If in fact that opening paragraph within the waiver precludes breach of fiduciary duty claims like you're suggesting, would it not necessarily preclude the terms of this agreement and the inapplicability or applicability of paragraph 6, the bylaw paragraph? Do you understand my question? What does terms of this agreement mean if, in fact, breach of fiduciary claims are not included per the opening paragraph?
Well, I think the terms are specifically focused on the waiver of personal injury and property damage and wrongful death claims. So
That's what terms of this agreement is referring to, is the type of things described in the first paragraph.
yes, I would agree with that. Circling back, I want to talk more about the unified procedure. I told you that there were 2 reasons why it could not apply. I think I only covered the first one. The second one is the exclusion provision, which I think is 10.d sub 3 sub h, which is what says that torts and other civil claims are not subject to the, torts and other civil claims are not subject to the unified procedure. So obviously that would cover this case, so the unified procedure simply cannot apply. And with that, my time will expire, so unless there are further questions.
Cool. Jacobson, for your helpful arguments today and for your good briefing. This case will be considered submitted, and we'll have a written decision as soon as we can. Thank you.